SJC-11426, Commonwealth versus Lewis Ortiz.
Good morning. May it please the court, Dana Currahan for Lewis Ortiz. I think this is probably the first time I have argued before this court where my only issue is a request for relief under 278-33E. But that being said, I think there are some fairly compelling circumstances here. I would like to focus on, first of all, the weight of the evidence, and second, the character of the defendant. Turning to the weight of the evidence, I concede that there was legally sufficient evidence to support a conviction of first-degree murder. When a jury hears a case, they are instructed to convict on the highest degree of guilt supported by the evidence. The jurors are not allowed to consider the weight of the evidence, and this court is. Looking at the jury here rejected the self-defense argument raised.
Can I ask you about that? Was it, and I may have this factually incorrect, but was it clear to the jury, I think there was some evidence that the shooting to the defendant's leg, he would have had to have done himself because there wasn't an exit hole, something like that.
There was some evidence to that fact. I think trial counsel conceded in his closing that that was probably caused by the defendant shooting himself.
So, okay, if that's the evidence, I'm puzzled on the self-defense other than a theoretical, well, Brown was in the house and he had a gun, but it wasn't, of course, Brown that he shot.
There was some testimony.
Yeah, whichever one.
There was testimony from various Commonwealth witnesses that anywhere from 2 to 4 shots were fired. Mr. Fontana said that there were 4 shots. If there were 4 shots, that would support the defendant's theory that a shot came from within the apartment, likely from the victim.
And it would because of the number of, why would it?
Why would it? Because, well, his testimony was that the door opened and he saw somebody pointing a gun at him. Right. A shot was fired and he shot back.
So this is a he shot back situation?
It is. And that
was there a search for bullets or bullet holes? Outside?
It's not.
Anything to suggest, anything to corroborate that there was a shot coming out, or that there was a shot from a gun that was different than the gun used to kill the victim and to shoot himself?
It's not clear. They never found the bullet that came out, that for shot number 3, where he shot himself, they never found that bullet. It's not clear whether they looked for it. So I'm not sure if there was, the search was somewhat deficient. They found that Mr. Brown had been hiding in the basement for several hours, but nobody ever searched the basement to see if there was a gun there. And that's the problem. That would have possibly yielded some exculpatory evidence. So again, the evidence before the jury would certainly support the conviction, but when we're looking at the self-defense theory, it's pretty clear that Mr. Brown had a gun. There was about 15 minutes between the time of the shooting and the time that the victim's girlfriend came out of the closet, where a gun could have been removed from the apartment. And so there is...
So the only evidence, really, that the victim shot at the defendant was the defendant's own testimony?
It's his testimony.
But other than that, there is nothing to corroborate it? There's
no direct evidence. There's no other direct evidence. But we do have evidence that Brown had a gun. He gave it to Mr. Cartagena. He returned to the apartment. Presumably, he would have had that gun in the apartment. No gun was found in the apartment, but Brown, of course, absented himself. Now, I think you also have to look at the circumstances of what happened when the door first opened. There's a knock on the door, the victim opened the door. This is like a scene out of a Quentin Tarantino movie. Both of them had the same expectation, that the person on the other side of the door was Cartagena, and that Cartagena was likely armed. So there's a real question about why the victim, Mr. Meltzer, would have opened the door unarmed, knowing that the person on the other side is probably Cartagena and that he was coming, likely coming armed. He had made several calls to Brown and to the victim's girlfriend saying, you know, Brown, you stole my drugs, I'm coming to get it, I'm coming to kill you, I want my money or I want my drugs. And so when the door...
Was there evidence that Meltzer knew of those calls?
Yes, he did. Well, obviously we can't ask him, but yes, absolutely.
I mean, they were all three there, and the calls were coming in fairly regularly.
That's
Is that
right. What had happened was Brown had ripped off Cartagena's drugs.
And they were using those drugs.
They were using the drugs.
These are calls to Brown's cell phone, not, there's no landlines anymore.
It was, I believe, Brown's cell phone, and I believe it may have also been the girlfriend's, Megan's cell phone. I'm not sure, but there were some calls there, and I think all three of them.
The reasonable inference that Meltzer would have known.
Yes, and I think there was some there was some testimony about some discussion. I don't recall the specifics, but I think there was some discussion that it was going to be Cartagena coming.
Now, when Cartagena was involved with Anjali, the sister of the defendant.
Yes.
In that episode of the kidnapping and the all of that, wasn't it that Brown had brought the gun to Cartagena?
Yes, he gave the gun to Cartagena.
So Cartagena then didn't have a gun other than the one. I mean, one could assume from this that perhaps Cartagena didn't have his own gun, which cuts against the theory that unless Cartagena was bringing the gun that Brown had given him, then the victim wouldn't have had that gun. You know, see what I'm saying?
I see what you're saying. It's
unless
not
we're assuming it. You know, there are multiple guns here, and I don't know what evidence there is of multiple guns.
Well, there's evidence that Cartagena was a guy who had guns, and in fact, the defendant's gun came from Cartagena.
The defendant's gun.
The defendant's gun came from Cartagena. He got the gun from Cartagena. So I think even if Brown had brought the gun back, his own gun back in there, there's evidence that Cartagena, if he wanted a gun, would probably have access to it. So I think there was testimony to that effect at trial.
But since Cartagena left, did he come back? In other words, after this drive, I'm trying to remember when he was at that house. After the drive with Anjali, did he come back to that house?
It's not clear. I don't think we know where Cartagena went after that. We do know that he was there that morning, and he was sort of in and out of that apartment. And I think that probably there was some not so savory activity going on out of that apartment. And it was pointed out as the defendant...
As in drug sales?
Drug sales, yes. The defendant was driving his sister to New Hampshire, and her testimony is that she said, "That's the apartment. That's where Brown is." At that point, the defendant circled around, stopped, put a pair of gloves on, put a gun in his waistband, and went up there. Now, that kind of brings me to my second point, that there is evidence that there was a degree of spontaneity. I know that it only takes a couple of seconds to premeditate, but I think the defendant went up there for a fist fight with Cartagena. He was armed, but when he knocked on the door, he didn't have the gun out.
Well, okay, but he specifically gets gloves. I mean, sounds like he's planning to shoot, doesn't it?
Well, I think that's what the jury found, but I also think that he had just found out, he knew about what happened to his sister, or he knew about the kidnapping all day, most of the day. But he found out about the sexual assault very shortly before that. They were at some kind of party, and that's when he found out. So it's consistent with the fact that he may be prepared to defend himself, or he may have been preparing for a fist fight, or for whatever happens. But I suggest that the evidence does not support, or it's at least against the weight of the evidence, that he went up there specifically planning to kill somebody.
Why would he have thought that Cartagena was there?
I think there's some evidence that Cartagena, that's the place where he hangs out. And by the way, if Brown was there, I don't think he would have any problem with going after Brown. I think his view was...
Brown was along on the escapade.
He was along on the escapade, and he provided the gun, and it was Brown's apartment.
That they were going to,
That that was Brown's apartment.
Right.
There's testimony to that effect. I don't think they were aware that Meltzer was there, or that his girlfriend were there. They were actually, I don't think they had been staying there permanently. They had been living in some kind of sober house or something like that, and they hadn't been there for that long. So I think he thought he would find either Brown or Cartagena or both. And yes, he armed himself, and he shouldn't have done that, but of course, I think if he was going up there for a fist fight, he probably is going to make sure that if he opened the door and there was somebody there who was armed, he's prepared to handle himself. And, you know, the fact that he had to pull the gun out only after the door opened suggests that this wasn't something that, well, he may have been prepared to do whatever was necessary. He wasn't there with a specific intent to do that.
Now, the jury, I gather, was given a reasonable provocation instruction?
Yes, they were. They were instructed on first degree, second degree, voluntary manslaughter, reasonable provocation. They were correctly instructed.
So how is this, apart from chivalry, how is this case different substantively from a gang retaliation case where somebody learns of the shooting of a very good friend and then goes out an hour later and retaliates?
I don't think when he found out about the sexual assault, he didn't just go out and retaliate and say, I'm going to go find this guy. He was driving his sister to New Hampshire, and she said, there's the apartment. And that was the decision. That's when he made the decision.
Isn't there a dispute about how it is that they got to go to the apartment? I thought that there was some evidence that he instructed his sister to drive him, and he was the one who was directing where they went.
His sister testified, and she was an immunized Commonwealth witness. She testified that she told him to stop there. She said that's the apartment and told him to stop there.
Am I wrong? There was no evidence to...
I think Fontanes may have said it was the defendant. You know, he was not a great witness for either side, but I think looking at the Commonwealth, I think the Commonwealth's main witness on this point was the sister, and she testified this is what happened.
But was it accessory before the fact? What was the crime what was she immunized for, if you know?
I'm not sure if there was anything, I know she was arrested. I don't remember what she was arrested for. But she and Fontanes were both immunized.
Right, I just couldn't.
So the only other point I'd like to make is that you know, this defendant had no prior criminal record other than a marijuana charge that was quaffed. He gave a very sincere and heartfelt apology at the time of his sentencing. I think this was completely out of character for him. This is not somebody who was running around committing crimes and getting into trouble. He had children. He was employed. It was completely out of character for him, and I'd ask this court to take that into consideration and consider a lesser degree of guilt. Unless there are any further questions, I'll leave the remaining points of the briefs.
Great,
Thanks,
thank you.
counsel.
Thank you.
Good morning, Your Honors. May it please the Court, Jamie Michael Charles on behalf of the Commonwealth, or for Middlesex on behalf of the Commonwealth. There were several facts that came out that the Commonwealth feels are inaccurate. I would just like to note that the most recent one, with regards to whether or not Angeli Ortiz was instructed to take the defendant to Shaw Street, came out in her testimony, page 40 to 42 in transcript volume 4. Angeli Ortiz testifies, contrary to what my brother indicated, that in fact she thought they were heading to New Hampshire, but the defendant directed her to the house on Shaw Street where Brown lived.
Directed her meaning he asked her where it was and she told him and that he drove there, or he knew where it was?
The defendant was not driving. Angeli was driving the car when they left. So prior to the shooting, the defendant, along with Louis Fontanez and his sister Angeli, were at a wake by the Lowell Superior Court. It is at that point at which the defendant allegedly learned of these additional facts regarding the kidnapping. They then depart the wake with Angeli driving, the defendant in the passenger seat, and Louis in the back. All the parties beyond the defendant believe they're heading to New Hampshire, where they are planning to drop the defendant off and take possession of his car so they can then use it the next day for a trip. The testimony that came out at trial was as the parties were approaching the entrance to the interstate, the defendant directed that they take a right instead of heading on to the interstate, and then asked Angeli to drive the car to Brown's house. I don't believe the defendant knew the exact address at that point. Clearly, Angeli was aware of where she had been earlier in the day, and the defendant directed her to take him there. But I think the weight of the evidence clearly supported the jury's conclusion here, both that the defendant had a specific intent to kill, and that he deliberately premeditated. As I've already alluded to, there was clearly a motive here. We obviously are not required to prove motive, but Angeli had been kidnapped earlier that same day at gunpoint by Brown and Cartagena. Regardless of what facts came out at what point, the defendant certainly knew hours before the murder that there was a pretty serious incident involving a gun, involving his sister and her son being taken hostage at gunpoint.
So what is your theory as to why he happened to shoot Meltzer?
The Commonwealth's theory, and the evidence bore this out, is essentially that the defendant went to the house expecting to see Brown or Cartagena. There really was no evidence that the defendant knew Meltzer or knew that Meltzer lived there. As my brother alluded to, he had only been there, and the evidence did come out to support this, for a number of weeks. He hadn't lived there very long. So the defendant went there with the intent to shoot and kill either Cartagena or Brown.
Who he knew?
Who he knew. The defendant was familiar with Brown and with Cartagena, and evidence came out of trial suggesting that he knew them. It was, in fact, Cartagena's gun that he had.
Right.
Why would he have shot Meltzer? Meltzer answers the door, he draws his weapon out and shoots him.
Although the Commonwealth doesn't feel it's necessary to parse when exactly the defendant drew the gun, whether he drew it after he knocked on the door or after the door opened, the evidence that came out of trial clearly suggested that the defendant went to that front door intending to shoot the person that opened the door, and that he believed it would be either Brown or Cartagena that answered the door, and he was planning to shoot and flee. And
But
frankly,
why would he have his gun in his waist as opposed to in his hand when he knocked on the door, if that was his intent?
Well, the defendant presumably put the gun in his waist so that he wasn't seen walking down the street from his car up the
before
drive.
he rang the bell.
Before he rang the bell. It seems as a distinction that doesn't bear a lot of consideration in this case. The fact is that he knocked on the door. Maybe he knocked on the door with the hand he holds his gun. And then he immediately took the gun out of his waistband. He shot himself before the door opened. There was testimony that there was one shot from multiple witnesses, that there was one shot, a brief pause, and then two more shots. So the defendant shot himself as he was pulling the gun out, and then Megan Grover's testimony was the second the door opened, she heard two shots. So the timeline suggests that the defendant knocked on the door, pulled his gun out. As he's pulling his gun out, shoots himself. And for the record, there was no dispute that he shot himself. The forensic evidence, Eric Koster from the crime lab, that's transcript 4, page 195 and 212, testified that there were no bullet holes, entrance bullet holes in the defendant's jeans, only exit wounds. And essentially, the defendant, when he took the stand in his own defense, admitted that he shot himself. So the defendant pulls his gun out after he knocks on the door, shoots himself as he's doing so, and then at the second the door opens, fires 2 more shots at close range into the victim Meltzer's chest and neck, and immediately flees the scene. And to be frank, had the defendant not actually shot himself at the scene and left forensic evidence at the doorstep, this probably becomes a much more difficult case for the Commonwealth. It's not even clear that this defendant would have been caught. But what it was clear.
The gun is never found.
The gun is never found because the defendant instructs Angeli and Louis to dispose of it. Angeli Ortiz drops the defendant and Louis Fontanez off at Lowell General Hospital. Angeli immediately leaves the scene to go meet Chris Garcia, another friend of the defendants who they were with at the wake who has gang affiliations. He takes possession of the bloody...
Are you suggesting this is a gang case?
No, the Commonwealth is not suggesting this is a gang case.
Does it matter that Garcia has...
The defense, part of the defense theory at trial was that this defendant was acting at the urge of some unsavory friends that he had who he didn't necessarily associate with from a gang perspective, but who were they were less savory characters than the defendant was, and that he is not the type of person who would normally shoot someone, but that he had been sort of egged on by, but in any case, he was familiar with and spent lots of time with this Chris Garcia character, who Angeli Ortiz immediately meets at the Heritage ice cream shop after she drops the defendant off at Lowell General, hands the bloody clothing and the gun off to Garcia. The gun presumably is taken away and disposed somewhere where it's never found. The bloody clothing is found right behind that Heritage ice cream shop 1 day later by an employee who notifies the police, who then come to that location, sees the evidence, DNA testing confirms that these are the clothes that have the defendant's blood on them. I would also note that the shirt that's found, the bloody shirt, is a dark-colored shirt which the defendant changed into on the way to the scene. If we're talking about the evidence of premeditation and intent to kill, so the defendant learns of this additional detail at the party. They leave the party. He doesn't go directly to the house. They stop at a gas station. The defendant goes inside and purchases something. The evidence as to what he purchased did not come out at trial. But they stopped, filled up the car. The defendant goes inside, conducts a transaction. They then get back in the car. He diverts the car towards the location of Shaw Street. En route to Shaw Street, he takes off a striped polo shirt. I believe it was a white and red striped polo shirt, fairly distinctive, that he is seen wearing on the surveillance video at the gas station. He changes into a dark-colored t-shirt. So he is now changed into much more muted, darker clothing in the car. They get to Shaw Street. He has them circle the block a couple times before the car is parked. He instructs his sister to keep the car running, to turn the headlights off. The fact that the car was running and the headlights were off were corroborated by eyewitnesses in surrounding houses. He then gets out of the car, asks Louis Fontanez to give him gloves. He puts the gloves on his hand. He goes to the back of the car. He takes a gun from the trunk, puts it in his waist pocket, and walks to the door. Immediately shoots Meltzer twice upon opening the door, runs back out, and flees in the car that was left running on the side of the road. There's plenty of evidence here that this defendant premeditated this attack, and there was no credible evidence that was against the weight of the evidence that suggests that he acted in self-defense, in a heat of passion, as a result of sudden combat. The defendant's self-serving testimony on the stand was really the only evidence. And mind you, this is not testimony that he ever, or statements he had ever given before. When interrogated by police, the defendant refused to acknowledge that he was even there. He fabricated this alibi about getting shot in a drive-by down the road by a liquor store. The officers press him repeatedly. If you look at the interview transcript, was this an act of self-defense? If it was self-defense, you can tell us. No, I wasn't there. He refused to even acknowledge his presence. This idea that he acted in self-defense and that this phantom gun, which, mind you, Angeli Ortiz and Megan Grover also testified was taken from the residence when Cartagena and Brown left with Angeli. This phantom gun that the defendant now, his only theory is, well, Brown must have brought the gun back to the house, and he must have given that gun to Meltzer, and then Meltzer shoots at my client, and Brown retrieves the gun and hides it.
No, but there's this whole
afterwards.
idea that there could be multiple guns, and that Cartagena was a source of some guns.
The Commonwealth will concede that there was evidence of at least 2 guns associated with Cartagena, the one that he deposited with Brown before it was subsequently taken away from the Shaw Street residence, and the gun that the defendant had. But again, and just to stress, there's no evidence that Meltzer knew or had any sort of idea about what kind of person Cartagena was. He may have known of him.
Well, Cartagena was the one that was calling that night, right?
Correct,
With
but for
the threats.
Brown. And,
Well-
and there's no evidence, as my brother suggests, that Cartagena said, I'm going to kill anybody. You know, he's coming to get his money, as I recall. And even if he did threaten to kill, he's threatening Brown. Meltzer doesn't steal anything from Cartagena. There's really very little evidence that Meltzer has any relationship with Cartagena.
He probably knows, though, doesn't he, that the drugs have been stolen from Cartagena? Because
He did know.
told, he and his girlfriend are basically told, why don't you go out and get some cocaine so we can do
Certainly. The Commonwealth...
speedballs?
Speedballs. The Commonwealth concedes that he was aware that the drugs were stolen.
Yeah, and so that he would have some idea that Cartagena would be unhappy about this and could be, and
Yes.
when the doorbell rings, I mean, it sounds like, when the knock comes on the door, it sounds like people panic, you know, and Brown goes off someplace, and the girlfriend goes into a closet, and for some reason, Meltzer is going to the door.
Sure. A couple points on that. Well, first, with regards to how Meltzer approached the door, there was clear testimony from Grover that not only was Meltzer not armed at the time he went to the door, she did not immediately go in the closet. She was in the doorway.
But she wasn't going to go to the door.
But she did not. No, there's no dispute to that. But she testified Meltzer is unarmed. She further testified that she's never seen Meltzer hold a weapon ever, or own a weapon, possess a weapon, hold a weapon. So that there was clear eyewitness testimony that he had no weapon when he went to the door. Why he went to the door, we can't know. Meltzer's dead. There's no way to ask him now. But it's clear that there was eyewitness testimony that he goes to the door unarmed, he opens the door, and as the door is in the process of being opened, he's already shot twice and falling back into the bathroom. Now, the defendant, mind you, made a central focus of his defense was to try and impugn the credibility of Grover. He brought in an expert and took measurements at the scene to suggest she couldn't have seen what she thought she saw. He pretty aggressively cross-examined her to the point that there had to be sidebars about her prior drug use and subsequent drug use and her visits to rehab. So he made a big effort at trial to discredit her eyewitness testimony. Despite all of these efforts and the defendant's testimony that Meltzer was armed and shot at him, the jury still convicted the defendant. And they did so after, over the Commonwealth's objection, receiving instructions on all theories of manslaughter, on self-defense, on first and second degree murder, proper jury instructions that are not disputed and that my brother concedes now are proper. So this is not a situation where this court should sit as a second jury, whether it believes that it might have come to a different conclusion itself. We have clear evidence of motive. We have evidence of planning and premeditation. We have an eyewitness to the crime who says the victim wasn't armed. We have the defendant's flight, alibi, refusal to acknowledge he was even there, disposal of evidence. The jury is instructed on all theories. And here's, in closing, you know, I could cite you a specific, he was overcome with emotion at page 7 of transcript 7 in the closing. You know, his sister had been sodomized, which, by the way, was not borne out by the evidence, and the Commonwealth objected subsequent to the closing argument. You know, Tim Brown had motive, means, and opportunity to get rid of the gun, page 11. The jury repeatedly got evidence and heard arguments that this was self-defense or a heat of passion shooting. And they clearly rejected that on proper instructions after a lengthy trial. And this is not a situation where the verdict was against the weight of the evidence. And so for those reasons, the Commonwealth would ask that this court affirm the defendant's conviction.
Thank you, counsel.
Thank you.